All right. All right, let's begin. I have 1 minute in my clock. Right. Hello, Agam, Savaz, Divya, everyone. Okay. Yeah. Any doubt from the last class that we had? Was it difficult or was it interesting that all of a sudden your idea of judiciary has expanded? Huh? I think it was interesting to learn about judiciary in this way because the task is to make sure that you are writing very good answer in the main examination, and that can only be achieved when your understanding is fundamental, not basic, fundamental, that you're aware about the nuances. All right. So, as I recall, I ended the last lecture with a specific statement that the freedom of any individual or the entire structure of the polity is meaningless if we do not have an independent judiciary, isn't it? This is how we thought about this topic. कि यदि आप ऐसे सोचें कि क्या बिना एक निष्पक्ष न्यायपालिका के स्वतंत्रता के कोई मायने हैं, is there anything in the polity that can ensure me freedom in a meaningful term or meaningful sense, then definitely there is none. You need an independent judiciary. We also understood what is the prime function of the judiciary. And through going through 5 functions, we actually focused on interpretation and protection. Okay, so constitutional interpretation and protection of the rights. That's why judiciary is called custodian of the constitution. Then we gradually moved to a detailed understanding of what is meant by interpreting the constitution and what is meant by protecting the rights of the citizens and the non-citizens or individuals, let's use the term, in a liberal democratic framework. We also understood why judiciary is important for dispute redressal. What's the point? And why dispute is bound to happen. There we linked it with the idea of political community, in which instead of based on ascription or ascriptive identities like class or caste and race, your caste, language, or any other ethnic identity, it is based on citizens. And as far as the citizens are concerned, when they become part of a political community, they decide certain rules and regulations to govern themselves. And definitely, there is going to be a conflict of interest in interpretation of those rules. And when that happens, the judiciary is considered as the final arbiter. The judiciary is the final arbiter which will decide which rule or what rule is correct. Then we further understood it from the perspective of lawmaking. And we had a detailed discussion on how judiciary gets involved in lawmaking. And this is something which is new, something which many of the scholars have not gone through yet, and a topic that requires further understanding. So the more we enter the domain of governance, how judiciary is involved in the process of governance, the more we will understand how judiciary is involved in law making. In the last class, we discussed 3 prime ways. So when judiciary is declaring a law to be null and void, that it makes judiciary involved in the law making process. Or when judiciary is reviewing something, or when judiciary is passing certain order, or when judiciary has passed a judgment, and that judgment has a precedental value. That judgment has an informative value. That judgment informs further judgments and orders that are about to come. And then in the last argument, we said that judiciary is necessary for a federal polity. We also understood what is meaning of federalism to some extent, not in detailed way, but to some extent. And in that, we further agreed that, all right, one of the prime conditions on the basis of which we consider a polity to be federal is that there is an independent judiciary as an arbiter. So this is what we have discussed in the previous class. All right. So today what we are going to do is we move forward. So we are going to understand what is the meaning of independent judiciary. And through this I will also link why Indian judicial system is called an integrated judiciary. We will go with a parallel. Then on what factors, or to put in other words, what are the ground issues or fundamental legal clauses that determine the independence of the judiciary, so that you are able to make a sense of what is the meaning of independent judiciary. So we go like this. We start with independence of the judiciary, है ना, एक स्वतंत्र न्यायपालिका, and we link it later with the idea of integrated judiciary. Not initially but later. We link both of them. Then we go further, or we unpack it, as I often do in my classes. We understand on what factors is the independence of judiciary dependent. Okay, so dependent factors. We understand this. All right. What are the prime conditions that are necessary for ensuring that there is a independent judiciary? Then we further understand why we need an independent judiciary, importance, or let's say significance. This part has already been covered in other way in the previous class. So this will be like a Rajdhani Express kind of. खट से हम लोग इसको करेंगे. Then after this, we bring out the third argument, that not only importance of the judiciary, but also what is the meaning of independent judiciary. Through reflecting upon the meaning of independent judiciary, three other questions or three prime issues emerge. One is relation of judiciary with the executive. Judiciary and executive. Second is relation of judiciary with the legislature. This is the second question or second topic which emerges from here. All right. And then we move forward. We further try to focus on, is independence of judiciary against accountability of the judiciary. So third topic which emerges from here is accountability of judiciary. So while going through all these topics, we will keep the Indian Constitution in the backdrop, so that we try to figure out how Indian Constitution is able to establish an independent judiciary. Difficult or interesting? क्या लगता है? Difficult होगा आज भी? ठीक है? Shall we start? All right, let's begin. ये आप लोगों ने बना लिया मैप, कॉन्सेप्ट मैप, बोर्ड पे जो है, कॉपी में अपने. ठीक है, थैंक यू. Let's begin. So as far as the idea of independent judiciary is concerned, it is coming from the doctrine of separation of power. which we have gone through in detail. We don't need to repeat it again. To paraphrase what it means in one statement is that all the organs of the government should be or should have clear, demarcated, separate zone of control. And one organ of the government should not interfere with another organ of the government. All right? So independence of the judiciary is coming from which idea? Doctrine of separation of power. Now in one of your topics of UPSC, you have to compare Indian polity or Indian constitutional scheme with other constitutions. If you recall what we have discussed about salient features of the Indian Constitution, there is something that I discussed, that if you look at United States, there is a separation, legislature, executive, judiciary. But if you look at UK, there is usually a concentration. There is a concentration of power. United Kingdom prefers other modes of parliamentary accountability to ensure that there is no tyranny. What is the idea coming from? Idea is very simple, that if there is no separation between organs of the government, it essentially means concentration of power. Alright, this is what the theoretical idea is all about. Which power? The power of the government or state. Now, as far as theory is concerned, this leads to tyranny. And tyranny is against individual liberty. This is conceptual argument. Because if there is concentration of power, definitely there is no check and balance in the polity. However, in United Kingdom, there is another method of parliamentary procedures through which, despite the concentration, people argue that tyranny cannot develop. However, there are some who say that there is an elected dictatorship sometimes visible in United Kingdom. As far as the framers of Indian Constitution were concerned, they were very clear that in India, even though we cannot follow the method adopted by framers of the American Constitution, but this does not mean that we are going to follow United Kingdom's model. So what they did, they were innovative in their approach. As far as legislature and executive is concerned, we see a concentration with all its parliamentary methods like collective responsibility, etc. But there is a strict separation here, legislature and executive on the one hand, let's call it A, and B is judiciary. So, instead of based on strict doctrine of separation of power, Indian Constitution is more based on a gentle separation and check and balance. Or, to put it in other words, a power sharing, a balanced power sharing, harmonious and balanced power sharing. For example, if you think about the terms separation of power from the perspective of Indian Constitution, we find it in directive principles of state policy. That in matter of policy execution and implementation, judiciary must be separate from the executive. If you read entire text of the Constitution, wherever the idea is mentioned about separation, it is mentioned in this sense only, that policy implementation level and execution level, there should be separation between executive and the judiciary. Otherwise, we are not following the model of United States. Rather, Constitution has framed or structured judiciary and other institutions in such a manner that there is a harmonious and balanced power sharing between each organ of the government. Now, this is your UPSC main examination question. UPSC has asked is that Indian institutional scheme is based on harmonious power sharing. The more we read and go through today's lecture, this argument will become further clear in your mind. All right? Have you noted it down in your copy? ये लिखा सबने? बनाया ग्राफ? All right. So let's write it down. अभी तो खाली मैप बनाया है. Let's have few statements written in your copy on this. Write give the heading independent judiciary. क्या heading लिखेंगे आप लोग? Independent judiciary. And in this start writing the idea of constituting an independent judiciary is outlined in the doctrine of separation of power. Full stop. As per this doctrine, the power of the state exercisable through the government should be maintained should be divided. The power of the state exercisable through the government should be divided between institutions to ensure and protect the liberty of the individual. Full stop. Next point. United States is considered as the polity based on this doctrine. Full stop. Next point. The polity of United Kingdom, the polity of United Kingdom is not based is not based on this doctrine. The polity of United Kingdom is not based on this doctrine. Full stop. To ensure that to ensure that the concentration of authority the concentration of authority is not putting individuals' liberty in jeopardy. To ensure that the concentration of authority is not putting the individual's liberty in jeopardy, their polity prefers the medium of numerous their polity prefers the medium of numerous parliamentary procedures. Polity prefers the medium of numerous parliamentary procedures. Full stop. Right, next point. The Indian Constitution envisages the Indian Constitution envisages a polity different from both United Kingdom and United States of America. In short form, you can write USA, from both United Kingdom and United States of America. Full stop. Next point. There is a concentration of power. There is a concentration of power between legislature and the executive. There is a concentration of power between legislature and the executive, comma, and a division of power, a division oblique separation of power, a division oblique separation of power between judiciary and these two institutions. Between judiciary and these two, you can also write organs of the government. These two organs of the government. Full stop. Right, next point. In matters of in matters of policy making and execution in matters of policy making and execution, comma, law making, bracket में write ordinary law, law making in bracket write ordinary law, comma, amendment, comma, amendment, bracket close. The Constitution expects a noble separation, a noble separation, full stop. Write next point. However, through the mechanism of judicial review, through the mechanism of judicial review and establishing the Supreme Court, as the final authority, establishing the Supreme Court as the final authority for protection and enforcement of fundamental rights, for the protection and enforcement of fundamental rights, comma, protection of the Constitution, comma, it creates a system of checks and balances, a system of checks and balances based on harmonious power sharing, based on harmonious power sharing. All right, full stop. Write final argument. This unique combination is present in, and write like this. First subpoint within this point. This unique combination is present in, write, structure and composition of the judiciary, structure and composition of the judiciary, right, appointment of judges, right, appointment of judges, right, jurisdiction of Supreme Court, jurisdiction of Supreme Court of India, Right, next sub point, matters pending before the court, matters pending before the court, right, appeal, and right, power to do complete justice. Full stop. All right. So, through all these different mechanisms, we not only witness the independence of the judiciary in Indian constitution or Indian polity, but we also witness how the power is balanced, shared harmoniously, and then there is check in other institutions and on other institutions as well. Any doubt? Has everyone written this? सबने लिखा अच्छे से? Clear? Structured pura. So what will happen after these 6 classes on Supreme Court? I'm damn sure that you won't need to worry about judiciary at all. Okay, because this is how I've designed these classes so that everything is covered and with a proper conceptual map. If you I think you have done this, add this to the map as well. हाँ, इसको मिटाते हैं फिर. All right, यहाँ से मिटा रहे हैं. Okay, now we move forward to how judiciary or independence of judiciary or how it is formed and on what factors independence of judiciary is dependent. हाँ, ये थोड़ा सा देख लेते हैं ताकि हो पाए. So suppose if UPSC main question is asked and they want you to write 150 words, you just have to write these arguments. And any points go 1, 2, 3, 4, 5, 6. 6 points, you have to just explain it. So 6 pointers and your answer is done. So through this method, you will also have a proper conceptual map plus a detailed understanding with intellectual depth that UPSC is expecting from all of you. Now let's talk about the factors on which it is dependent. Now there are many ways to understand this. What determines the independence of the judiciary? When we say that we have an independent judiciary in India, why we claim this? There has to be some evidence. We need to provide some evidences. All right. So we start like this. First, within this, the factor on which it is dependent, the first has to do with formation of the judiciary. Formation of judiciary. In other words, how judiciary is constituted. How judiciary is constituted. This is the first thing that we have to remember. So what do I mean by this? If you follow or you try to figure out how judiciary is constituted in other parts or other polities, then there are multiple methods, historically as well as in our contemporary time period, that what is available around us. One of the ways, and it sometimes happen at the small level at United States as well, that people have a lot of matter, a lot of say in it. So elected by the public. There is one method like this. Elected by the public. Now this argument, often you must have heard this, ये सुना होगा बहुत लोगों ने, that judiciary is so powerful, but it is not elected by the people. We are a democracy. People should decide who can become a judge. Isn't it? ये argument दे दिया जाता है that there should be election or some kind of accountability, a democratic accountability of the judiciary. And often people think that by democratic accountability, we mean that they must be elected by the public. Now, this is a problem. So what happens if we follow this method of forming judiciary through elections? Then there is a likelihood, there is a possibility. There is a possibility. So what is problem in this method? That there is a possibility that a person who is not even qualified to be elected as a judge can get elected because of his popular appeal. All right. So an unqualified person can enter or could enter the corridors of judiciary because of the popular appeal. This is the first and, let's say, the fundamental fear if we follow the method of election leading to constitution and formation of judiciary. There is another method. The second method is that judiciary is elected or constituted by the legislature. All right, which is, let's say, in Indian context, parliament. This is another way of ensuring that there is some amount of accountability as far as constitution of judiciary is concerned. कि जिन लोगों को हमने चुना है, people whom we have elected, they decide who will become the judge. On one level, it looks nice, कि fine, we are electing the member of parliament, and these member of parliament must decide who can become a judge. Now, what is the problem here? The prime issue or the fundamental fear if we follow this method is that the bad effects of party politics can or could lead to selection of individuals as judges who have their ideological allegiance to a party or an ideology and not to the constitution. Isn't it? This is the fundamental fear here, that the people will have ideological affiliation. Ideological affiliation to a party or an idea, but not the constitution. This is the fundamental fear here. All right. This is the problem with this method. Now there is a third method. The third method is that instead of legislature, judiciary or people who are appointed in judiciary as judges, it should be done by the executive. All right, by the executive. Now, as far as polity is concerned, and consensus on the method of electing the judges is concerned, this is considered as the most, or let's say the best way to ensure that there is an independent judiciary. There is a consensus on this method. To ensure independence, there is a consensus that executive must have a big say in appointment of the judges. It is also considered as the most satisfying method. If you look at India, we follow this method. Even in, let's say, at the higher judiciary level, we also have this method in other developed democracies. But what is the fundamental fear here? That even though it is going to protect us from unqualified people becoming judges due to popular appeal or the fear of party politics, there is a possibility that judiciary will remain under the control of executive. if there is no check and balance, judiciary will remain under the control of executive. So despite this being the most satisfying method of appointing the judges, there is this lingering fear that judiciary will always remain under the control of executive, and in order to ensure that there is independence of judiciary in a fundamental sense, the constitution must address this fear. Alright, so write it down. Have you written it? Do I need to dictate it? लिख लिया है सब लोगों ने या इसको डिक्टेट करना है? Do you want to write it? लिख लिया है? Good. तो आगे बढ़े फिर इससे? All right. Then I'm going to इसको मिटा देते हैं फिर. Because this is like I'm already writing on the board, so you can write it on yourself, isn't it? All right. So इसको मिटाते हैं. So these are fundamental aspects, formation of judiciary, etc., etc. So, in what manner does the Indian Constitution addresses this problem? इस पे बात कर लेते हैं. So, as far as appointment of judges is concerned, Indian Constitution is clear that they will be the judges of the Supreme Court. We are talking about the Supreme Court, the Union Judiciary. They will be appointed by the President, right? This is what the Constitution says. Now, President here is the head of the Union Executive, isn't it? So, definitely, we have executive share in the appointment. But, as far as the Constitution is concerned, the executive cannot remove the judges. Alright, so they can only appoint. If we have to talk about this sphere, as far as appointment is concerned, the executive has a say. But when we talk about removal, executive has no say in this. So write this argument. Okay, write it. ये सब लिखने के बाद we write, as far as appointment by the executive is concerned, as far as appointment by the executive is concerned, the Indian Constitution developed a method of balanced power sharing. The Indian Constitution developed a method of balanced power sharing to ensure that the judiciary remains independent. That the judiciary remains independent. And now write next point. Start like this. As per Article 124 of the Indian Constitution, as per Article 124 of the Indian Constitution, the executive plays an important role. The executive plays an important role in the appointment, but it has no control, on removal of judges. It has no control on removal of judges. Full stop. Only the parliament has the power to remove a judge. Only the parliament has the power to remove a judge despite the fact that the judiciary can conduct an internal inquiry, and declare a judge to be incompetent, all right. इस तरीके से आप इसे समझ सकते हैं. So moving forward, let's understand what article 124 has mentioned about these fears, and through this we will cover this article today only. ठीक है, आगे बढ़ें. Alright, इसको मिटाते हैं. Let's look at article 124 कि उसमें कैसे बात की गई है कि आपका वो आर्टिकल शुरू हो. So if you look at Indian Constitution and especially many of you have gone through Union Executive, then we have gone through the Parliament, huh? If you look at part 5 which deals with the Union, huh? Part 5 which deals with the Union, in this chapter 4 is about the Union Judiciary. ठीक है, chapter 4. As far as this part is concerned, it deals with the Union, and this chapter is about the Union Judiciary. Now we have covered other parts, alright, in the classes before. Today we are discussing it, and it starts with article 124 and 147 it reaches, huh? So we are on the article 124. Now let's see how Indian Constitution has an entire structure to ensure that as far as appointment and removal is concerned, there is independence of judiciary. So we discussed that one of the major factor is how judiciary is constituted. And we went through 3 methods and the fear. One is by election, one is by legislature, and one is by executive. And we just went through fear of everyone. Here unqualified person can enter, here party politics, and here executive control. These are the 3 prime fears of in each method. Now what article 124 has to offer about all the fears and everything? Let's begin like this. As far as article 124 is concerned, it states that there will be a Supreme Court of India. The first thing which is very clear is that there shall be a Supreme Court of India. And the meaning of word shall here is that there is no possibility that we cannot have a Supreme Court. And in this it mentions that this Supreme Court of India shall be the highest judicial body. That there shall be a Supreme Court of India which is the highest judicial body. First thing. Number 1. Then this article further states that as far as appointment and independence is concerned, if we look at the perspective of the question of appointment and independence, the article is clear. First, the judges will be appointed without any legislative control. Alright, so there is non-involvement of legislature. First thing, non-involvement of legislature. This is the first thing which is clear. So this fear is addressed. Similarly, there is non-involvement of people. Second part is clear as well. Second fear is also clear. Then this article states that as far as appointment is concerned, a person must have experience of advocacy or being a judge. Alright, so there has to be some kind of judicial experience. So, even though this is ensured, the possibility of an unqualified person or person having party allegiance through executive route is also curtailed down. So every fear is addressed here. Then this article goes further. If you look at the text of the Constitution, as per this article, there are other elements that the executive can appoint, as I just mentioned. It cannot remove. This is the third fact which comes in. It cannot remove. So executive control fear is addressed through this. Then the article states that as far as appointment is concerned, the president will appoint these judges through his signature writing under his hand. And there is a question of political controversy, but only the president can do it. So the fourth factor which comes in, that the president is going to appoint. And if we merge these two, we get a clear analysis of how independence of judiciary is ensured. For example, in order to be qualified to be appointed as a judge, the Constitution is clear. Number one, the person must be a citizen of India. First fact. The person must be a citizen of India. Then it moves further, that the person must have been judge of a high court or two or more such courts for at least 10 consecutive years. Alright, so what it states, number one, citizen of India. Number two, must have been judge of a high court or two or more such courts for at least a period of, and it writes very clearly, there should be no gap as such, consecutive 10 years. So judicial experience, right? It's not the case that anybody can become or appointed as a judge in the Supreme Court. It goes further. If we extend the third argument as far as this article is concerned, third one here, that if not the judge of a high court or any such court, must have been an advocate of a high court or two or more such courts for at least a period of 10 consecutive years. So, advocate of a high court or two or more such courts, and again the Constitution is very clear, for a consecutive period of 10 years. This is again mentioned in the text of the Constitution, Article 124, clause 3. Then there is another argument here that okay, fine, these three are happening. There is one more. The person is a distinguished jurist in opinion of the president. That the person is a distinguished jurist in opinion of president. And then there is one more explanation. So what happens? Sometimes in the judicial system of India, people are, let's say, advocate, but at the same time, during for a brief period of time, without any gap, they also hold some judicial office. All right. Now the Constitution explains this, and sometimes UPSC asks the question on this argument that while computing these 10 years in matter of advocate, if a person without break has occupied a judicial office, be very careful in listening, has occupied a judicial office which is not inferior, all right, some judicial office which is not inferior to that of a district judge, then the time that person has acted in capacity as that officer, which is not below to the rank of a district judge, even that time period will be added to these consecutive 10 years. All right, so there is an explanation about holding an office not inferior to a district judge. There is another explanation in this article, Article 124, Clause 3. 124, Clause 3. That explanation is not very relevant today, because when India became independent, before independence, there were high courts in this country when we were subject of the British. So that explanation is about that high court means any court which practiced jurisdiction or which had jurisdiction in India or in the territory of India before the commencement of the Constitution. Because after the commencement of the Constitution, the system of court became integrated under the Supreme Court, the new judiciary that we had. So there is an explanation that people who are working as judges under the British governance, even they will have chance or opportunity to be appointed as the judges in the Supreme Court. So there is an explanation for allowing those judges to become part of the Supreme Court. That explanation is not much relevant for our purpose. This explanation is relevant. So write it down. I want all of you to write it down. Right. Article 124(1) of the Indian Constitution, Article 124, Clause 1 of the Indian Constitution states that there shall be, and underline the word shall, states that there shall be a Supreme Court of India, a Supreme Court of India, which is the highest judicial body, which is the highest judicial body in Indian Republic, which is the highest judicial body in Indian Republic. Then write next point in this. Article 124, Clause 1, Article 124, Clause 1 and 124, Clause 3, Article 124 Clause 1 and 124 Clause 3 ensure that disqualified individuals and individuals governed by legislature's influence remain out of judiciary. Full stop. Despite following the executive route, the Indian Constitution through the provision of judicial experience as the prime basis of appointment ensures independence of the judiciary. Right, next point. Article 124 Clause 2. Article 124 Clause 2 states that the judges of the Supreme Court shall be appointed by the President by writing under his hand, or say by warrant under his hand, because President is going to issue like this, na? So by warrant under his hand and seal. Full stop. Right, next point. Article 124 Clause 3. Article 124 Clause 3 states the qualifications necessary for appointment of an individual as a judge of the Supreme Court of India. Now we will have sub-points. Number 1, she or he must be a citizen of India. Number 2, she or he must have been, she or he must have been a judge of a high court, a judge of a high court, or or of two or more such courts, of two or more such courts for at least, and underline it now, for at least 10 consecutive years, for at least, underline, 10 consecutive years. Full stop. Write next point. She or he must have been, she or he must have been an advocate, an advocate of a high court, of a high court, or two or more such courts, two or more such courts for at least, for at least 10 years, 10 consecutive years, okay, for at least 10 consecutive years. Right, next point, there is an argument of succession as well, we will come to it later. Just write next point. So consecutive means immediately, na, ek ke baad ek succession, right? She or he is, she or he is a distinguished jurist, she or he is a distinguished jurist. So the person knows about law. So distinguished jurist means what? So think about the constitutional advisor to the Constitutional Assembly, Sir Benegal Rao, B.N. Singh. So he knew about law, na? So that kind of person is known as a distinguished jurist. So Dr. Ambedkar will be a distinguished jurist. So she or he is a distinguished jurist in the opinion of the president. In the opinion of the president. Now there is one thing which you all must keep in mind. One of the conditions is mandatory. So all these conditions are mandatory, but other conditions can substitute for one another. What is the mandatory condition where we can have no substitution? That mandatory condition is that the person must be a citizen of India. If a person is not a citizen of India and that person is a distinguished jurist, it is not going to happen. The person has to be a citizen of India. But whereas other conditions are concerned of being a judge in a high court or two or more such courts for a period of consecutive 10 years, or being an advocate of a high court or two or more such courts for a period of consecutive 10 years, there is an oblique. So or that person can be distinguished jurist. So these can be substituted. If not the judge of a high court, the person can be advocate. If not the advocate, the person can be a distinguished jurist. But in each and every matter, that person has to be a citizen of India. Right? The next point. In these conditions, except the clause of being a citizen, except the clause of being a citizen of India, other conditions are of substitute variety. Other conditions are of substitute variety. full stop. Right, next point. Article 124 clause 3 contains an explanation regarding the condition of being an advocate, regarding the condition of being an advocate, full stop. It states that while computing the time of being an advocate, while computing the time of being an advocate, for 10 consecutive years, comma, any period in which a person has held judicial office not inferior to that of a district judge, and underline, after he became an advocate, that of a district judge, underline now, after he became an advocate, shall be included. All right, shall be included. ठीक है? Any doubt so far? Any doubt, anyone? So this is a position, okay? There can be no dual positions. Attorney General and Solicitor General are actually advocates who are working. They perform the task of being an advocate. The time period is counted. They are acting in capacity as an advocate for the government, on part of the government. So they are advocate of that record, and that's why many people get promoted to that level. So, but it is not going to happen when both things are going on equally. All right, think like this. Yeah. And then there is one more thing. Yeah, one more thing. So in one of the Supreme Court judgments, the court decided that while taking these kind of cases into account, we must understand whether or not the appointment is based on being a distinguished jurist or advocate, or whether the intention is some kind of ideological affiliation. So there, I'm remembering the judgment there. It's one of the very fundamental judgments in Indian history. We will discuss that later. So there is one clause in that judgment which puts a bar on these kind of appointments. Not just this, even let's say a person who was an advocate and then after for a or during a brief period of time was acting as capacity of a not inferior to a district judge, or was working like a judicial official in a non-partisan manner, let's say, even then also the court looks into the intention behind the appointment sometimes. So even this clause is there in one of the judgments. All right, any other doubt? And then there is one more argument here, which is clearly. So remember always, these positions of solicitor or in the state level advocate or additional solicitor general or attorney general, these are legal positions, number one. They're out there to ensure that the so-called taraju and the hanging of justice is ensured, right? So they're like making case on behalf of the government. They have a say, but they are not legislative position. First of all, these are legal judicial positions. So then also this period is counted because they are acting in capacity as an advocate. Remember, he's an advocate, so don't forget that. All right. Any other doubt regarding this? Okay, shall we move forward? All right, let's move. So if you think about these issues, so when we talked about formation, whether or not formation is through legislature, executive or any other matter, we discussed that there is an executive route which is commonly accepted, and the prime fear is that there will be control by the executive, right? So if you think about Indian Constitution in Article 124, what we have covered so far, that definitely the executive plays a part. The president is going to appoint them. But even here, the question that executive authority will not be controlling the appointment of judiciary is not answered. It is only answered in some manner. Let's say 50%, that there is a judicial experience required. These points. But even then, there is a possibility of executive control. Yes or no? Despite this judicial capacity argument that the person must have a judicial experience, there is a possibility. Now there, the court has other mechanism as well. One method of ensuring that there is no judicial dependence on the executive is that you take away the removing power from the executive, right? So we move on to that argument. Let me remove this. So for example, if you think about removal, one method of ensuring independence of judiciary, or which is depended upon, is to ensure that the executive is not involved in the removal of judges. Now here, let me bring what Indian Constitution has to offer. So as far as the Constitution is concerned, and Article 124 only is concerned, when we talk about executive, it has a role in appointment. But when we talk about removal, executive has no role in removal. As far as removal is concerned, we have legislature. Moreover, as far as resigning is concerned, that a judge resigns, there also executive has no role. It is prerogative of the judge who is thinking to resign. So let's move like this. All right, let's write it down. Right, in matter of removal of the judge, of Supreme Court, in matter of removal of the judge of Supreme Court, the executive has no authority. The executive has no authority. As per Article 124, Clause 4, so 124.4, right, both the articles. As per Article 124, Clause 4, majorly write this abhi. The legislature has an active role. The legislature has an active role in removal in removal of a judge of the Supreme Court. In removal of a judge of the Supreme Court. Alright. Before going into this article, let's have some other arguments which determine the independence of judiciary, the factors on which it is dependent. Oh, it's 6:26. Arey, you people are not tired? थकान नहीं हुआ आप लोगों को? नहीं बच्चों सुनो, there are people who are going through online class. Take a 5 minutes break. So 6:25, let's meet on 6:30. Take a 5 minutes break. Mark your attendance. Are you all here? Or if any of you is here? Okay, the person is here. Huh? Let's move forward. So we keep this in the backdrop, and then we discuss some other factors on which the independence of judiciary is dependent, and then I will come back to it. Don't erase it, just keep it in the backdrop. Huh? Okay, let's move forward. So the second factor within independence of judiciary, second factor as far as the formation or composition is concerned, formation or composition of judiciary is concerned, the first was appointment, right? This is what we have discussed so far. This is done. The second one is also we have discussed, which is, we move forward, now we come here, second one. The second one deals with access to the judiciary. This also we have discussed through Article 124. Now what do I mean by it? It means whether or not the talented or eligible individuals are able to enter judiciary. Now, if you just go through the notes and Article 124, when I said that a person must be a judge or an advocate for at least 10 years consecutive in succession, or the person is a distinguished jurist, or the person has been an advocate and after that the person has also occupied a judicial office not lower to the that of district judge, this factor is also taken into account, right? I don't think there is any doubt which is going to pop up in your mind regarding this. The third factor on which independence of judiciary is concerned is that the appointment is non-discriminatory. Non-discrimination. It means that irrespective of which caste, which class, which region, which linguistic identity, cultural identity, irrespective of all of these, the individual, only on the basis of his qualification, is able or is eligible to be appointed as a judge of the Supreme Court. So if you again go back to Article 124, what we have written and what I have made you all to write, this factor is also taken into account, isn't it? Yes or no? Is Article 124 mentioning any kind of discriminatory principle? Isn't it? So even if you think about it, there is an element of independence in the Indian Constitution. There is a fourth element in it. But what happens here, just in your copy, write debate. And from here, very important topic of the main examination pops up, which is about National Judicial Appointment Commission case or versus, let's say, Collegium System. All right, this is your main examination topic. In this only, there is one more argument about transparency in the appointment of judges. We will discuss it, if not today, in tomorrow class. Transparency in appointment of judges. All right, this is one topic which is current issue, relevant. It could be asked in the main examination. ठीक है, ये आ सकता है. So the next factor that I want all of you to think upon, on which the independence of judiciary is dependent to a large scale, is that there is a constitutional guarantee of the independence of judges. Because what we are going to write now deals with this constitutional guarantee of independence of judges. Often what happens when someone is trying to read or prepare herself for UPSC, what they do, they try to mug up the articles, and I don't like mugging up of every article, because it's more about how much depth of understanding you have about any apparatus. Now, if you think about this factor, so think like this. We have read what we have discussed. Number one, if you think about this, number one, in matters of appointment, the constitution is clear. President is going to appoint the judges of Supreme Court, etc., etc. And wherever the constitution is silent, it inevitably means that the judiciary has a larger say. So wherever constitution is silent, the judiciary has a larger say. So National Judicial Appointment Commission issue, how judges are selected, appointed, it deals with this point, that there is a constitutional guarantee of independence of judges. More than this, if we move a bit further, when we talk about removal and resignation, we are talking about constitutional guarantee. Okay, so second is removal and resignation. So when we discuss this point, we have to keep in mind what the constitution has to say about removal and resignation of the judges. Then there is a third element in it, that the constitution must have something to say, or there must be some provision based on which the judges are able to deliver judgments without any fear. The third factor that is important here to keep in mind, that whether or not judges are able to deliver judgment without fear. So, dear aspirants, now we move on to this argument. So, have you written whether access is open for eligible individuals? Right? Write like this. In addition to, right, the next point, within this larger argument of independence of judiciary heading, right, in addition to appointment, the independence of judiciary is dependent upon these factors as well, is dependent upon these factors as well. Right, number 1, whether eligible and talented individuals, whether eligible and talented individuals could get appointed as judge of the Supreme Court, could get appointed as judge of the Supreme Court. Right, next sub point, whether the constitutional provision regarding appointment is non-discriminatory in nature, And write next argument, next point, whether the text of the Constitution or the essence of the Constitution, whether the text of the Constitution or the essence of the Constitution guarantees the independence of judges, Now write, we are going to write in this point sub-points. Write sub-point number 1, whether the judiciary has a say in appointment of judges, whether the judiciary has a say in appointment of judges. First point. So let's discuss this first, then we move forward. Okay? Let's discuss what do we have to offer here. If you think about the Indian Constitution, Article 124 states that all the judges of Supreme Court will be appointed by the President. This is what the Constitution has to say. If you think about the exact language, because there is one question that often asks how many judges are in the Supreme Court, etc., etc. The exact language of the Constitution is very clear. The Constitution states that as far as judiciary is concerned, there shall be Supreme Court of India consisting of a Chief Justice of India. Okay, this is how the Constitution goes, Article 124. That there shall be a Supreme Court of India consisting of Chief Justice of India, number 1. Alright, so Chief Justice of India is one judge of a Supreme Court. And then it states that until Parliament by law prescribes, other judges. Okay, at time of independence we had 7. Now the number has increased. Can anyone give a guess how many judges are there in the court now? Anybody? किसी को ही पता है अब कितने जजेस हैं हमारे पास? Anyone? फटाफट बताइए. It's very simple. या नहीं पता है, 33 may be correct. So there are 33 other judges. So remember, what is UPSC going to ask you here? How many judges are in the Supreme Court? And does the total number of judges include the CGI? What will be your answer? Constitution is clear. One is CJI, and then there are other judges. They are now 33 in number. Okay? Okay? This is how you have to answer this question. This is a pre-examination question. Now the point is, who becomes the Chief Justice of India and who is appointed as other judges? So there is a problem here. As far as Constitutional Convention goes and the text of the Constitution goes, there is a point of recommendation. There is a word called recommendation. Now, if you think about this word, there is a question that must come in your mind. Does recommendation means concurrence or not? It means that whomsoever name is suggested, is President going to accept that name only or not? As far as Indian constitutional history is concerned, which, let's say, as far as the judiciary is concerned, for almost so many years of Indian Republic, there is a convention that the Chief Justice of India suggests certain names and then they become or they are appointed as the judges of Supreme Court. Alright, so there is a suggestion by the CJI, and this suggestion is coming from a collegial system, system of collegium. As far as this person is concerned, usually the senior most judge of Supreme Court is appointed as the Chief Justice of India. Only in entire constitutional history, this convention has not been followed, only 2 times. One is when Justice A.N. Ray was superseded to become the Chief Justice of India. The other case is of Mr. H.M. Beg. If we remove these 2 cases, when there was a very strong government in power, if we remove these 2 cases, rest every time the most senior most judge was appointed as the Chief Justice of India. This is like very clear. So this is how Constitution has defined it, and this is how people are working in this polity. But there emerged a debate about concurrence, like complete acceptance. Now, as far as constitutional history is concerned, as far as the history of Indian Constitution is concerned, initially the court decided, let's move forward. So as far as Indian judicial system's history is concerned, and if you look at the historical cases, this idea that the president must agree with whatever names which are suggested to him or her is of a recent invention. Initially, if you think about the cases in this matter, there are 3 very prime cases known as the 3 judges cases. So think like this. There is one thing called first judges case. They are known in parlance like this. For today, write the names like this only. First judges case. There is a second judges case. And then there is a third judges case. In all these 3 cases, gradually the doctrine or clarity on this word, whether a recommendation means concurrence, has become further clear or has been cleared. In the first judge's case, This was the time when the court used to take a very textual approach of the constitution. Okay. And this time the court used to take a very textual approach. If not in every matter, in many matters, okay, till like let's say 1970s precisely, but in this case also the court took a textual approach. Now what do I mean by it? If you think in terms of polity, and especially the task of interpreting the constitution, if you think in terms of interpreting the constitution, there are many ways to interpret something. So suppose it is written that let's say there is a statement that there shall be a council of ministers to aid and advise the president. All right, this is the text of the constitution. Now there can be many meanings to it. One meaning could be that fine, the constitution is stating that there shall be a council of ministers. The other meaning could be, okay, the constitution is mentioning about the council of ministers because the constitution wants to develop a democratic republic. And in democratic republic, there is no space for executive outreach, right? Instead of executive outreach, we need a representative government. Then there could be a third approach as well, which is like, fine, the constitution is talking about democratic republic, but in times of need, we can rely on something else. And then there could be something more to it, like the judges could say that if there is no council of ministers, the president cannot function properly, or it is mandatory to have a council of ministers despite the fact that there is no government taking legitimacy from the parliament. So there can be many interpretations, there can be many methods of interpretation. Similarly, a more simple example could be of fundamental rights and directive principles of state policy. For example, as far as the constitution is concerned, fundamental rights are justiciable in a court of law. Article 32 states that if your fundamental rights have been violated, you can reach court to enforce fundamental rights. This is one argument, enforce fundamental rights. But the constitution also says that part 4, or let's say the DPSP, are non-justiciable, right? This is how the constitution is mentioning. Now if we follow a textual approach, what it means that fundamental rights have a upper position in comparison to directive principles of state policy. Clear, or any doubt in this argument? Is this argument clear? Right? Okay. But in comparison to the textual approach, there are other approaches. Let's say some original approaches, or let's say thinking about constitution as a living document. So let's say if we think about constitution as a living document, then in this, entire interpretation will change. For example, the court will argue something else. The court will consider both these articles and both these parts as a product of history. The court will say that when the Indian Constitution was being framed, at that time, the way constitutions used to be framed, they had these kind of separations, number one. Number two, the court will say that even though the constitutions used to have these kind of separations, Indian constitution makers were innovative in their approach. That unlike other constitutions, for example, the constitution of Germany or Ireland, where both kind of rights were part of the same chapter, the Indian framers decided to differentiate, divide it. Alright, they can give second argument to this. They could say that because the framers decided that Indian polity and Indian economy is not strong enough to enforce directive principles, we need to make them non-justiciable. That a person should not go to court for enforcing these rights. And then the court will come with the fourth argument. Due to lack of economic resources, the framers decided to put these rights under the category of non-justiciable rights. But it doesn't mean that these rights are secondary to fundamental rights. They are of equal footing, a co-equal status. This is a different interpretation. And then the court will bring out another argument that fine, as per Article 13 and Article 32, executive and legislative action should not violate fundamental right. But as per directive principles, it is obligatory and mandatory, both. So state has an obligation and it is mandatory for the state to apply these principles in making law. So even though these principles are non-justiciable, they are nevertheless, and this is what the Constitution says, they are nevertheless fundamental in the governance of the country. UPSC has asked this question as well, that which part or which articles are fundamental in the governance of the country. So, even though they are non-justiciable, they have a co-equal status with fundamental rights, and because they have co-equal status with fundamental rights, the state has a binding obligation and a binding duty to frame laws according to these principles. Now, if you compare a textual approach to a living document approach or an original approach, it gives a more nuanced understanding of the provision of the Constitution. Yes or no? Is this clear, this argument? Or do you need more explanation on it? So there is a difference, na? That if you follow a textual approach, you will be very narrow in your orientation. बहुत ही संकुचित नजरिया, सीमित नजरिए से आप देखेंगे. But if you follow a more broad approach, where you look at history, where you look at polity, where you look at economy, and then you look at the words of the Constitution in a, let's say, progressive manner, then the entire interpretation changes. This is what happened in matter of appointment of judges and the question of recommendation and concurrence. That if these justices or Chief Justice of India is recommending some names, does it mean that the president has to follow that advice? Or the president can deny to follow that advice and appoint someone? Now what happened here? In the first judge's case in 1981, the court followed this kind of approach, a very textual approach. And the court said that as far as appointment of judges is concerned, the executive should not follow whatever the judges are saying. So recommendation doesn't mean concurrence. What the court said in this case? Recommendation doesn't mean concurrence. So the executive can deny to accept the recommendations of judiciary. Now what happened here? Suddenly court through itself gave upper hand to the executive. Executive got the upper hand. But then things change. With 1981 we move forward. The moment we reach 1993, which is the second judge's case, 1993. In this, the court overturned its previous judgment. This is also coming from a constitutional article that the Supreme Court has this power. So what happens? By 1993, entire period from 1975, we have a very strong government in the center. The court is not that strong in comparison to the government, which is legislature and then executive. The parliament and the executive are very powerful between 1970 and 75. Then we have, during the same period, we have emergency in this country. So it was a different time period. But with 1981, and if we move forward with 1985, suddenly the nature of India changed. Why it changed? New issues started coming up. The nature of judiciary had changed as well. There was a transition going on in Indian judiciary. Whether it is the Menka Gandhi case, whether it is R.C. Cooper case, any case you bring in. And even during the same time, by 1973, court had already talked about the basic structure. So what happened here when 1993? The court said that even though the constitution is mentioning that the executive shall appoint the judiciary, that the president will appoint the judiciary, the same constitution has talked about a separation of power and has created a polity where independence of judiciary is paramount. And therefore, because the constitution is silent, the judiciary decided to overturn its own judgment. And in 1993 case, they said that recommendation by judges and especially Chief Justice of India is of significant value. And therefore, it is not the executive that is going to decide who is going to be appointed as the judge. The power of the executive is only about appointment. It's not about deciding. Okay, here the court changed its position that the executive has only the power to appoint. Who will get appointed? Their names are going to be suggested by the judiciary. And there, from this case, the system of collegium actually started. What is collegium? To be in very simple word, collegium means the process through which the judge of the Supreme Court, especially Chief Justice of India, with other judges, I will tell you the number in a while because the next case has more to say on that. The judges of the Supreme Court, the Chief Justice of India with some other judges, will decide who is going to be appointed, who is going to be promoted, and who is going to be transferred. These three are prerogative of the judiciary because they are necessary to maintain the separation of power between executive and judiciary. The power of the executive is only to work on the recommendations given by the judiciary. Their power is not about deciding who is going to be recommended. This is how they changed. Now, back in 1993, the wheel turned in favor of judiciary. So, what the judges did in this case, they decided that the appointment, the names for appointment will be decided by Chief Justice and two senior most judges. So, Chief Justice of India plus two senior most judges of Supreme Court. In the third judge's case, again, they extended this argument. So by 1997, when this case happened, they again reiterated that the Constitution stands for independence of judiciary, that the Constitution stands for separation of power between executive and the judiciary. Therefore, the judges are going to decide whose name will be recommended, and the executive has to accept that demand. What they changed? They changed the number of judges. So, in addition to Chief Justice of India, now it will be 4 more judges. So, CJI plus 4 senior most judges of Supreme Court. So, this is how constitutional history has developed. Now, I want all of you to write for some more minutes. Then we move forward. Right. Under the heading of constitutional guarantee, write first appointment. Start writing. The Constitution states that the Supreme Court of India, the Constitution states that the Supreme Court of India shall consist of Chief Justice of India and other judges which the Parliament, and underline now, which the Parliament by law prescribes. Alright? Now, what I want all of you to do in your copy is that when you circle this word and circle Parliament as well, and write here legislature and constitution, like this, chota sa keyword. So as you can see, even though the president is going to appoint, the number of judges of Supreme Court is not decided by the executive. The number of judges is decided by the legislature. Alright, so there is a separation here as well. Executive is not getting the entire power. We will discuss it in some time. Just do this. Write legislature and keep this law word circled. What it means here, it's a different term here. Then write the Constitution is silent on the issue of the Constitution is silent on the issue of division between recommendation and concurrence. Division between recommendation and concurrence. Full stop. Right, next point. It is a constitutional practice. It is a constitutional practice to appoint the senior most judge of the Supreme Court, to appoint the senior most judge of the Supreme Court as the Chief Justice of India. As the Chief Justice of India. Full stop. Write in continuation that the other judges are appointed on the advice and recommendation of the Chief Justice of India. Full stop. Write in the same point, the number of other judges is 33 in number. Is 33. The number of other judges is 33, and in bracket write 7 at the time of independence. In bracket write 7 at the time of independence. Write next point, 7 at the time of independence. Write next point. Gradually, the judiciary has developed a collegium system. Gradually, the judiciary has developed a collegium system which is at the center, which is at the center of controversy, center of controversy in Indian polity, in Indian polity. And then give a dash, write National Judicial Appointment Commission, National Judicial Appointment Commission, comma, issue of transparency, issue of transparency, give another dash, UPSC main, issue of transparency, UPSC main. ठीक है, we will discuss National Judicial Appointment Commission tomorrow and the issue. For now, write the next point. The Collegium System, the Collegium System refers to the process, refers to the process through which the judges of Supreme Court, the judges of Supreme Court, within bracket write CJI, which means Chief Justice of India, and 4 senior most judges. CJI plus 4 senior most judges. All right, refers to the process through which the judges of Supreme Court of India, within bracket CJI plus 4 more judges, decide about appointment, comma, promotion, appointment, comma, promotion, comma, transfer, appointment, comma, promotion, comma, transfer of the judges in the Indian judicial system, of the judges in the Indian judicial system. Right, next point, historical development of Collegium System, historical development of Collegium System, dash, it has developed through 3 prime cases, through 3 prime cases, full stop. Underline this statement. It is not mentioned, it is not mentioned in the Constitution. It is not mentioned in the Constitution. Within this, write the first judge's case, 1981. The first judge's case, 1981. Dash. In this case, the court decided in favor of the executive. In this case, the court decided in favor of the executive. Full stop. It meant that the executive is not bounded, is not bounded to act as per the recommendation of the judiciary. The recommendation of the judiciary in matter of appointment. In matter of appointment. So another thought here. So when we are writing the president is going to appoint, I think all of you have this in mind, that president actually means the council of ministers, because president has to work on aid and advise of the council of ministers. So government, ruling party is involved, right? That's why there is this tussle here. Okay, so keep this in backdrop. Appointment of judges is a political activity. That is why there is this debate. Then write the next argument. In the second judge's case, 1993, in the second judge's case, 1993, the court adopted a more original reading of the Constitution. The court adopted a more original reading of the Constitution and decided that the executive must follow and accept, that the executive must follow and accept the recommendations of the judiciary. Full stop. Right. Recommendation means concurrence. Recommendation means concurrence. Full stop. The court stated that the CJI, which means Chief Justice of India, CJI, with two senior-most judges of Supreme Court, will take or will have the ultimate say in matters about appointment. Full stop. This case marks the beginning of Collegium System, in India. Full stop. The court reiterated its position in the third judge's case in 1997. The court reiterated its position in the third judge's case in 1997. Full stop. It stated that the CJI, which means the Chief Justice of India, CJI, with four senior most judges, of the Supreme Court, shall have the ultimate say in matter of appointment and other in the judiciary. All right, in the judiciary. Right, next point, the tradition of appointing the senior most judge of Supreme Court as CJI has been broken for 2 times only, dash, right, 1973 within bracket A and Ray, 1973 A and Ray, and give a comma and write 1975 HM Beg, right, 1975 HM Beg. All right. So if we think about this entire collegium system which I just discussed and the matter of appointment of judges, we can see that with time, through reading of the constitution in a different manner, the court has been able to ensure independence, isn't it? So there are 3 things which emerge here on which I want to conclude today's class. Any doubt so far? I hope all of you have written about the collegium system definition. Huh? Any doubt? You can send it in the chat box. So if we think in terms of appointment and independence and constitutional guarantee, let's see what the constitution has to offer. Right, let's see. Now it is bounding because they cannot go against it, and this will become further clear because the judges have said this. Now what we have around, if not, I think we have around 4 minutes. So let me give you a brief picture of what is about to come and what we have discussed, how it is linked. See here. So we said that independence of judiciary is important, right? This is what we have discussed. And the previous class we have discussed that judiciary ensures rule of law. So significance is already inherent. We have covered it, so I'm not going to invest much time on that. And then we said it is dependent upon many factors, isn't it? And one of the factors was that the appointment is based on constitutional ground. It is connected with appointment. And in appointment, we discussed that there are multiple routes. The most satisfying route is the executive route. And I want all of you to write bullet like this. Okay. Then we said that there is a fear. The fear is about executive outreach. And then we discussed that there are many ways in which a constitution can take care of this fear. One is by declaring certain conditions of appointment. For example, it should be fair. It should be non-discriminatory, right? And qualified people must be able to enter the judiciary. The second was, the constitution can give appointment power to the executive but not the power to remove. As I have mentioned, in Indian context, it is the legislature that can remove. Then there is another third element through which this executive outreach can be checked. How many judges will be appointed is also decided by the parliament. Number of judges appointed is decided by the legislature. Right? We discussed this as well. Now here is a problem. Two problems emerge which further elaborate upon. So, no power to remove, conditions of appointment, and number of judges. Now here constitution is saying by law. And this is where I want to bring the entire class to an end. Whenever you read the word law in the constitution, it has two meanings. One is by law. One word is this. And there is another word which says parliament through law or by making a law. Okay? Making a law. Let's put it in a simple term. The term law here has two different meanings. On one hand, we are talking about the constitution as a text. We are talking about constitution. And here we are referring to the ordinary law making power of the parliament. Here law is connected to the idea of basic structure. And in one element of basic structure is separation of power. So, the judiciary decided to develop a collegium system to ensure not only there is a protection against executive outreach, but also there is a protection against legislative outreach. Why? Because in Indian polity, legislature and executive are actually combined. Legislature and executive are combined. Executive is emerging from the legislature, isn't it? That is why the constitution is not only against this outreach, it is also against this outreach, and then the court decided to have a collegium system. But the question of transparency remains. So if you think about independence of judges and judiciary and about appointment, this is how you have to think about this entire matter, how things have developed. UPSC asks another question from here, which is, what kind of reforms are needed in the judiciary? It deals with this question: is collegium system transparent? UPSC asks another question. The two names that I have made all of you to write, H.M. Beg and A.N. Ray. Sometimes people write M.H. Beg, but H.M. Beg is the final way. They are the only two names and the 2 years when the convention of appointing the senior most judge as the CJI was broken. UPSC asks a pre-question from there as well. In the next class, we will deal with the proper clause of removal of the judge of a Supreme Court. We will deal with the age of the judges of Supreme Court. We will look at what are other factors guaranteed in the Constitution to ensure independence of judiciary. And then we will look at the entire debate of National Judicial Appointment Commission. All right? Till then, thank you. Any doubt? All clear for today's class? How things are connected? लिख लोगे मेन का आंसर? ये जरूर करना है बोर्ड पे. All right. See you all tomorrow.